It's Entertainment Law Update, episode number 150 for October 26th, 2022. Hello, and welcome to another episode of Entertainment Law Update. From Los Angeles, California, I'm Gordon Firemark.
And from the Dallas-Fort Worth Metroplex, I'm Tamara Bennett.
And thank you so much for being here with us today. This is our podcast about entertainment law, where each month we pull together a roundup of legal and business news stories and share our opinions and commentary and analysis about them. What's new with you, Tamara?
Oh gosh, Gordon. Well, I am just home for about 48 hours after 21 days on the road. So I'm glad to be home.
Okay.
Glad to be getting up and going to bed in my own house. Had a great trip to see our son Brock, who moved to Austria. Johnny and I, my husband and I, had already had a cruise planned to transatlantic from Barcelona into the lovely port of New Jersey. There was lots of beautiful things in between. So when Brock made the decision he was taking a job in Austria, we tacked on a few days to the beginning of our trip and got to go see him in his new home for at least the next 9 months. And,
nice.
It was really fabulous to disconnect from work, not for the whole time, but for a big chunk of that time. So a big shout out to Angela, woohoo,
Nice.
who kept everything rolling in my absence and back to earth. I will say the plus side of the transatlantic going the direction we did was that we gained an hour every day.
Oh.
So
you
by
don't
the
have the
time
jet
we
lag.
got back, you have a little bit of vacation lag, but you don't really have the jet lag. It was so fun to ask the staff people on the cruise what they did, with the extra hour, and it was laundry. So it allowed them to, they really did get 25 hours a day in on their continued work. So anyway, that's what we've been up to. We have been from Dallas to Frankfurt, a train from Frankfurt to where we went, Salzburg, Austria, then a train from Salzburg to Klagenfurt, which is where Brock is home, and then reverse that in a flight to Barcelona.
Nice.
Then Barcelona around the coast of Spain and Portugal, and then across the Atlantic. So it has been an adventure. So glad to be home in the Dallas-Fort Worth Metroplex. What's up with you, Gordon?
I'm jealous. I don't have anything exciting to report. No world travel, no nothing like that. It's been a pretty quiet couple of months now, and that's okay with me, really.
Yeah, me too. We were both ready to come home. I'm always ready to come home. My husband, not so much, but he was.
Yeah. Well, we are celebrating a milestone with this show. It's 150 episodes that we've done. 150 monthly episodes. That's really something.
It really is something, and we're celebrating it by actually doing this on a video as well.
Yeah.
So our first run at that for me. So I apologize. It will get better.
Which video may or may not ever be seen by anybody.
That's right. We're doing a test run.
It's
Gordon
is
very qualified. I, on the other hand, am lacking a little bit, even though I have a media degree.
Yes.
We digress.
Well, let's get started by just giving our I don't know what to remembering Mary Beth Peters, the longtime Register of Copyrights, passed away earlier this month, and we just wanted to say a few words. I believe you said you met her a couple of times.
I did. I just had I actually do think I've met her twice. In particular, what stands out to me is in 2007. I cannot believe it's been that long ago. Miss Peters was honored by the Entertainment Law Institute, State Bar of Texas, Sports and Entertainment Law section, really with it's called the Star Award, but for her contributions to the entertainment industry. And she was so delightful. I have to tell you, she really took the time to speak with all of the attorneys that were present. We broke bread together at a luncheon and a dinner. And I don't know. I just was so honored to make her acquaintance and to actually, see all the things she's done throughout her career. I posted on my Facebook, she was such an amazing role model for women. And a mutual friend of ours, Steve Winogradsky, who's a
Yeah.
longtime friend, colleague, attorney, said, well, she's not just a role model for women. She was a role model for all of us. And I'm
Yeah.
like, you're correct. So anyway, that's kind of my remembrance of Mary Beth Peters and how delightful she was, and just that she took the time, and
Yeah.
she was really one of us, and that was a great thing for me to see
Mhm.
as a younger lawyer. Uh, Even though I guess I'd been practicing for about 10 years at that point,
Mhm.
but still
Mhm.
felt like I was a young lawyer in the
Yeah, she was
business.
very giving, and I remember seeing her on panels and discussions, and always full of advice, not just information about what the office was doing, but she would actually sort of give tips and advice, and it,
Yeah,
there to help really, and to serve the copyright community. And anyway, she'll be missed. So
she will. She will. So I'm glad we could honor her, and she will be missed.
yeah. Well, our first case to talk about is Melendez versus Sirius XM. John Edward Melendez, you might have probably heard of him as Stuttering John from The Howard Stern Show. He was on the show from 1988 until 2004. And a couple of years after he left the show, Stern entered into that $500 million agreement with SiriusXM, through which it obtained a license to air all the current and new episodes of the show, as well as much of the archive, lots of full and partial past episodes from the show. Melendez appears in many of these archive episodes, excerpts of which SiriusXM uses in its online and on-air advertisements to promote the Stern Show. So Melendez claimed that these advertisements were a violation of his right of publicity under California's common and statutory law right of publicity statute, because his identity, persona, name, and image were being exploited for SiriusXM's commercial gain without his permission. So he sued SiriusXM in the Southern District of New York, alleging a breach of this right of publicity under California law, one common law, another one statutory, and Sirius moved to dismiss that claim, which was granted. The court explained that Melendez had failed to plead any facts plausibly suggesting that SiriusXM's intended audience could reasonably construe advertisements for the Howard Stern Show featuring him as his endorsement of SiriusXM or any of its non-Stern Show channels. They also said that Melendez's publicity rights claims were effectively claims for the wrongful rebroadcasting of copyrightable sound recordings. So the allegations were not qualitatively different from copyright infringement claims, and therefore were preempted. And so he appealed to the Second Circuit, and let's just run down quickly the elements of the common law cause of action in California. This is misappropriation of the plaintiff's identifying characteristics. The defendant used the plaintiff's identity. The appropriation was for defendant's advantage, commercial or otherwise, without consent, and there being a resulting injury. And then under the statute, the elements are a knowing use by the defendant and a direct connection between the use and the commercial purpose. So,
But on the statute, it's
yeah,
the first four plus two,
right.
right? It's an even higher
Mhm.
standard and I'm guessing so. It's a New York case, but we're talking California law.
Because I guess he's a California resident, and therefore
Okay.
the injury hits him there. So Section 301 of the Copyright Act specifically addresses preemption and the situations where preemption applies. And the state, the application is that in applying the statute to determine if a state law claim is preempted by Copyright Act, courts in the Second Circuit apply a two-part test, both parts of which have to be satisfied. The first prong is the subject matter requirement, and the second, the general scope or equivalence requirement. So, subject matter requirement is satisfied when the plaintiff's claim applies to a work of authorship fixed in a tangible medium of expression and falling within the ambit of one of the categories of copyrightable works and so on. So no indication from Melendez's allegations in the complaint that SiriusXM had usurped his identity to sell a product or service, a personal endorsement with which the plaintiff had no relevant connection. So they're basically saying, hey, he was part of the show. It's, sort of reasonable. The challenge advertisements are the same for the same show, not a separate product that he never had anything to do with. So the court said this is sort of like an advertisement for the broadcast of an upcoming football game by the NFL, using footage from a prior game or something like that. Neither of which is considered a personal endorsement by the player of the game or the channel or any of that. And then the general scope requirement, for that to be satisfied, the state law claim must involve acts of reproduction, adaptation, performance, distribution, or display, and must not include any extra elements that make it qualitatively different from a copyright infringement claim. So if there is no extra element, then it's preempted, essentially. So here, the cause of action was violation for these violations. Normally, for a statutory claim under right of publicity, there's the extra element of the commercial purpose. But that, the Second Circuit says, doesn't sufficiently change the nature of a similar state law claim so that it's qualitatively different from a copyright infringement claim. That's kind of interesting. I think the commercial, well, we can just debate that all until the cows come home. The court then explained that they must look to what he seeks to protect. His right of publicity claims are simply attempts to prevent SiriusXM from rebroadcasting in advertisements for the Howard Stern Show on their channel and elsewhere portions of those archival episodes in which he appeared. Ultimately, his right of publicity claims then under both common law and statutory law are aimed at stopping that reproduction of copyrightable works that embody his identity. So the court said that, look, these right of publicity claims in this lawsuit are based on works that come within the subject matter of copyright under Section 102A of the Copyright Act, and the right being asserted is equivalent to the exclusive rights within the general scope of copyright. So the lower court was right. They upheld the dismissal on preemption.
And I think we must have talked about this when the case was first filed as well, maybe 18 months ago.
When it was dismissed.
When it was dismissed. But I think it's right. I think there is a preemption issue here. It is so woven into the copyright claim and to this sound recording or video, audiovisual work that was created for the show. I just don't know that there is a right of publicity claim. You would have thought that there would have been a release that included his publicity rights. I know he's probably chapped that he's not getting paid again. I think that's it. And I don't know if there were other co-talent on the program that got paid. Or is it just him? I know there were other reoccurring characters on the Stern Show.
Well, he wasn't a part of the $500 million deal. And I think if he had been still a part of the show, then he would be seeing some reward for that. But I sort of understand his being chapped, as you describe it, and sort of justifiably so. But the right of publicity said, just in this case, look, he agreed to be in these copyrighted episodes and in this content, and they belong to the Stern people. And when they licensed them, that's, you can't stop them from using that stuff that he appeared in to promote those things, right? So,
right.
Yeah, I get it, but he doesn't get it in this case. The preemption is there.
Unfortunately, depending on which side you're on.
And it's important to note that this is not a categorical statement that copyright always preempts the right of publicity. It was in this particular fact scenario where he was willingly appearing in the material when it was created, and that it was being now repurposed for marketing purposes, but not for something separate and distinct from the original show. Does that ring true for you? Is that sort of...
I think so. So I have a hypothetical right of publicity question that was presented to me. let me get your take under California law
Okay.
and see what you think. Uh, a someone under 18, so they're a minor,
Hmm.
and they are recorded for a commercial purpose. Parents are divorced. Do you think both parents need to consent for their image to be used?
Under California law, I think neither parent has the authority to consent. Under California law, the minor is the party to the contract, and we have a mechanism for court approval of minors' contracts to make that valid and binding. Um, and so that would be the mechanism, especially for an ad. I would say you get the kid, you get the kid. Well, if it's a long running campaign, you're going to go to the trouble of getting this court approval thing. If it's a one off kind of a thing, then parents' consent is probably the pragmatic approach to it. Yeah, because you don't want parents coming in and claiming some kind of exploitation of the child or something like that. But no, I think as a production company that you want the contract to be binding, and I don't know whether the court would care about both parents' consent. That's an interesting question. I've done those court approvals on a few instances with just one parent signing, when there
Yeah,
was
so
no
then
objection from the other parent.
right, and so it was an interesting little part of this hypothetical was that as part of the assume that as part of the divorce
Mm-hmm.
decree and child custody
Yeah,
agreement that either parent could give legal consent, and so would
or a
consent from
specified
one
parent.
be equal to yeah, well in this case
Yeah.
that it was a joint but not mutual.
Mm.
So anyway, just throwing out there that was an interesting right of publicity question I've had recently, and I was like, well, if I was the other side of the deal, I would get permission from both parents before I took off on this, relying on permission from one
Yeah, I mean, in
as
practice, I think,
wise counsel.
yeah, in practice, I think that's what I would do is make sure I have both of them, so there's no later argument from one. I didn't give consent, and I don't agree, and ultimately that's a family law matter, the disagreement over whether they should have consented, but you don't want to be stuck in the middle of that. So.
Yeah, and I think that was just for me a great intersection of family law and what we do.
Mm-hmm, mm-hmm.
When you're dealing with a minor child, obviously. Anyway, so
My
sorry, just
suspicion
throwing
is
that
it's
out
not as
there.
hypothetical as you're telling us it is, but presented as a hypothetical.
They
So,
present it as a hypothetical.
yeah.
So anyway, just throwing out a real life practice pointer for folks to think about there.
So, what if you want to if the minor wants to get a tattoo? Which parent? No, anyway,
Yeah, well,
we're going
that
to talk
also
about,
goes to that decree.
right, right. Well, we're going to talk about a couple of different cases involving tattoos that we've talked about these before, but we've got some resolution. Um, Catherine Alexander is the tattoo artist in the first of our cases that we're going to talk about, who has received an award from a jury in Illinois for damages in the trial against Take-Two Interactive. The jury decided that the use of the tattoos on wrestler Randy Orton, so Alexander had tattooed the wrestler Randy Orton, and got a copyright registration just before filing the lawsuit against Take-Two. Take-Two included Orton as a wrestler in its WWE 2K series of games, and thus included the tattoos for a realistic depiction of the wrestler. Under the Solid Oak case, which we've talked about not too long ago, this type of use was deemed to be permissible in a summary judgment motion as a de minimis use, an implied license, fair use, and those kinds of things. What the court here ruled shortly before the trial that de minimis use would not apply, and it didn't provide any instructions to the jury on implied licenses or a waiver kind of a defense. So in the court's pretrial order and in accordance with Google versus Oracle, the fair use case from a couple of years ago, fair use is a mixed question of law and fact, so the judge ultimately should have been responsible for determining whether or not fair use applied. It should have been noted. It should be noted, that the court had previously denied a summary judgment motion on this as well. So the court. So it goes to the jury. The court also failed to provide the jury with instruction on whether waiver or implied licenses, those kinds of things. So the decision by the jury, not fair use, it's copyright infringement and pay up, but the amount of the award is what's sort of interesting here, $3,750. So you got to wonder, how much did this litigation cost in order to get to a $4,000?
And I'm wondering if that was, I don't know how much a tattoo cost. Surely a tattoo doesn't cost that much, but that was some number that the plaintiff proved up. Has to be.
Well,
I guess
it's probably a number that the defense proved up. If you find an infringement, then it really only amounts to this much, right?
Yeah. So this is interesting. So our notes say that neither party filed or made a claim as to the jury instructions. They should have put onto the record an objection to the jury instructions to preserve that for appeal. And it's unclear to me if that was done, because seems like the plaintiff's counsel would have made an objection.
You would think.
To the form of the jury instruction, because this doesn't even sound like they use a standard jury pattern.
Right. Well, yeah, and the defense would have said, well, wait a minute, we should also have the waiver and we should also have the implied license, Yeah, so it sounds like it sounds like the judge may have been a little just perturbed at the case even being in his court, to be honest.
Well, and then, would this, I'm thinking, would this have been a case that would have been appropriate for the new small claims court?
Yeah.
Probably, maybe not, because plaintiff was probably claiming damages in excess of $30,000, which I think is the minimum for the copyright.
Yeah, but with the timing of the registration of the copyright, the statutory damages would have been out the window. So, how does she prove that up?
Right. This would have been filed prior to the court being available.
Yeah.
But looking forward, would this be the type of claim that might be appropriate to go into the small claims court?
Yeah. So there may still be an appeal. We don't know whether they made the record to preserve some objections and those kinds of things, but certainly it sounds like a very limited set of jury instructions was given, and there wasn't any appeal of that earlier summary judgment that we know of. So, we'll see. And the question is really, do either of the parties have the inclination or want to devote the resources to an appeal on something like this? I think that the game company has an interest in getting an outcome that they can live with. This is not that. So they'll probably appeal.
And I don't think this is anything that rises to the level of a split sufficient to go all the way up. But we clearly have other cases where they're saying using the tattoos is part of their persona, and it's a fair use. It's a de minimis use.
Yeah. I mean, there's that whatchamacallit, Oak case, and
I'm looking down here. Under Solid Oak, a New York District Court case,
and we may get something this next Supreme Court term that helps us figure out where fair use boundaries are as well, from the Warhol case that we're going to talk about a little later on. Although how transformative is anyway, that's the question. So a question for fair use. So anyway.
Yeah.
Our other. Go ahead.
We have another tattoo. Well, I was just going to say we have another tattoo case, which is interesting facts. Okay. So Cardi B, the recording artist performer, won a jury trial against Kevin Michael Brophy. I'm going to go with that for the last name, regarding a misappropriation of his likeness and false light defamation. So the artist Cardi B was making a cover for her mixtape and decided she did not like the tattoos that were actually on the back of the other person that was in the cover on the mixtape. The other person that was in the cover on the mixtape, I'm guessing, let's see, was placed in such a way it looked like there was a very intimate action happening between Cardi B and this person.
I'm going to be more specific. It looked like he was giving her oral sex. So,
Or,
uh,
uh, but Cardi B didn't like the tattoos on that guy's
yeah.
back. So she goes to Google, finds some tattoos she likes better, has them photoshopped onto the back of the guy on her tape, and we go from there. So Mr. Brophy alleges the cover art went against everything he stood for. He had attempted to contact Marty B's team prior to filing suit. I guess that didn't pan out, obviously. And so they go to trial and have a jury decision and against Cardi B and say she's not liable, or the case is against her, and argues the model's face was never shown. So that's the
Mm-hmm.
Mr. Brophy's face was never shown. It was also, there was a difference in race. The
Mm-hmm.
cover on the mixtape was an African American. Mr. Brophy is a white man with a shaved head. There was no way to identify Brophy, the plaintiff in this case, and so he loses in his false light claim and use of his likeness on the tape, even though perhaps these were very identifiable tattoos. But different, it's not the tattoo artist bringing the claim.
Right. Here it was, yeah, this guy Brophy was claiming that the tattoo was such a distinctive part of his identity that it was essentially portraying him, even though he's a white man with a shaved head, and the model on the cover was a black man with hair. So it was just down to, well, that's my tattoo, so that reflects on me, essentially.
Yeah,
And
and it's
the jury
so
didn't buy it.
maybe if Mr. Brophy was, well, it would be a little bit different standard. We're going to talk about that if he was famous or he was someone in the, the public eye, that there
Mm-hmm.
could have been a greater connection. But, that's not the facts we have here.
Well, and in a copyright in a tattoo copyright scenario, we have seen a tattoo that originated on a black man, Mike Tyson.
That's
It,
right.
it was later, shown on Ed Helms' face in the movie Hangover 2, and there was a brouhaha about that. That's quite a while ago now, but so it's not unheard of to have a cross race issue around this kind of thing. But here the jury said, yeah, but that's not identifying you, so it's not your claim to make. And he was a good sport about it. Apparently, after the trial was over and the jury verdict was read, he went and shook her hand, and he was congratulatory, and in an interview said something along the lines of, "Well, I couldn't have just let it go. I had to stand up for myself, but that's how the cookie crumbles." And he was, sort of accepting.
Okay.
Yeah.
Yeah. And I think talking about the Tyson case,
Mm-hmm.
because that is on Mike Tyson's face, you don't see Mike Tyson without it. I'm
Right.
assuming Mr. Brophy, there's times when he has a shirt on. We're
Sure.
not seeing his back. Um,
Yeah.
I think that's a little bit of a distinction. I guess in the Tyson case, they settled. We didn't get a
Right.
decision
Right.
on that. And it was such a key and classic part of that movie
Yeah.
as well.
So what's interesting here is that this is a right of publicity case, essentially, about the tattoo. I wonder what would have happened if the tattoo artist had been the one making, well, it wouldn't be making the right of publicity claim, but is it theoretically possible that this tattoo artist who did this intricate design on Brophy's back is is going to claim copyright
Well,
infringement?
and I wonder, we're doing a lot of hypothetical.
Yes.
I think this is a situation where the tattoo artist might really have a copyright
Yeah.
claim.
Yeah.
If it is an original work that is protectable by copyright.
Yeah.
I don't know that. I haven't seen the design, nor am I going to make an opinion on whether or not the Copyright Office would grant a registration.
And
But
de minimis and fair use and implied licenses and all those other factors.
yeah, but this was clearly for a commercial purpose.
Yeah.
And I don't think there was any transformation, just you took it off of
Yeah.
a light background and put it onto a dark background.
Yeah.
So
Mhm.
And I think that's an interesting kind of case there to think
Yes,
about.
indeed.
When might it really be something that a tattoo artist could really pursue?
Yeah.
So
Yeah. Hmm. Well, let me ask you a question. Do you think that Roy Moore is a public figure?
I think he is now.
Well, he
But I know that's not the standard. The question was he a public figure when all of, uh, I'm sure he felt like his life was falling apart around him was going
well,
on.
I mean, he was nominated for the Attorney General of the United States. He was wasn't he the governor? No, he was a Supreme Court justice in Alabama, right? Um,
Well, was he nominated? So sorry, in 2017, Jeff Sessions was
oh, right, right,
nominated
right.
to the Attorney General. Roy
Oh, his Senate
Moore,
seat was yeah, of course.
right. Roy Moore was nominated by the Republican Party to take Jeff Sessions' Senate
That yeah,
seat. But
that.
Mr. Moore had been a Supreme Court justice in Alabama.
Hmm.
Um, you know, I,
Yeah,
I think that makes you a public
yeah,
figure if you're a state Supreme Court justice. I think you
yeah.
are.
So, amidst the campaigning for that special election in 2017 to fill the seat that was vacated when Jeff Sessions became Attorney General, um, the Washington Post ran a story November 9th, 2017. So, right there, detailing the experiences of several women who alleged that Moore had sought out relationships with them when they were teenagers. And that article said that Wendy Miller says she was 14 and working as a Santa's helper at the Gadsden, Alabama mall when Moore first approached her, and 16 when he asked her on dates with which her mother forbade. The New American Journal published a story a few days later that noted sources tell me Moore was actually banned from the Gadsden Mall and the YMCA for his inappropriate behavior soliciting sex from young girls. Lastly, AL.com published a story about the same time stating that Wendy Miller told the Post that she was 14 and working as Santa's helper at the Gadsden Mall in 1977 when Moore first spoke with her and told her she looked pretty. 2 years later, when she was 16, he asked her out on dates, though her mother wouldn't let her go. So these articles were used by a Democratic super PAC called Senate Majority Project. They used these articles as a base for TV ads against Moore. And the ads juxtaposed the following phrases on the screen. One, Moore was actually banned from the Gadsden Mall for soliciting sex from young girls. And then it quoted the New American Journal, it referenced the New American Journal article. And another one he approached was 14 and working as a Santa's helper. And that was another one referencing the AL.com article. So after he lost the election, Moore sued the Senate Majority Project and a number of other entities in federal court alleging that he was defamed. He argued that the two quotes were, when pieced together, made it appear that Miller was one of the girls whom he solicited for sex. And in response, the defense argued that the two quotes were themselves factually accurate and did not, and were not intended to suggest that Miller was one of the women Moore solicited for sex. Additionally, the defense argued that regardless of the gist of the statements was true, because Moore was well known in Gadsden for trying to pick up teenage girls at the mall and for attempting to have sexual relationships with teenage girls. So
Wow.
the jury, go ahead. Were you going to say something?
Well, the verdict, no, just the jury verdict said that each of these issues was deemed to be a triable issue of fact for the jury to decide. Well, obviously,
Okay.
the judge said that in a pretrial ruling. But following the trial, the jury found in favor of Moore $8.2 million in damages. The jury demanded that the Democratic super PAC, SMP, the jury determined, sorry, that SMP made a false and defamatory statement about Moore that also placed him in a false light in the public eye. The PAC plans on appealing this. So I guess the question is, why is this decision important?
Hmm.
First, the pretrial decision does not have a finding of, and in fact, openly questions the necessity of actual malice. So this is where we started our conversation on
Yeah.
this: is he a public figure? Which, according to Times v. Sullivan, right?
Yeah.
We've got to have a showing of actual malice for a public figure to prove defamation. What's the standard? Actual malice is present when the publisher of the information had acknowledged the information was false or showed a reckless disregard for whether the information was true or false. Removing this standard would make it easier and for public figures to sue over comments by others. And so I guess my question is, are we going to remove this standard for public figures? Is this what this case is doing?
It sure seems that the pretrial decision by, to let it go to the jury on the facts as presented, it sounds like the judge is saying Sullivan doesn't apply. And, that's peculiar to me. It's a Supreme Court decision, and now we have a state court saying not going to use it.
Yeah.
Not following precedent, not following stare decisis. And it didn't seem to make a persuasive distinction between a normal public figure case and this for some reason. So, it certainly seems like grounds for appeal. We haven't heard about an appeal yet.
It could be important also, this case regarding advertising concerns. When there's a risk that an entity takes on running similar advertisements. I mean, obviously they took these quotes.
Yeah.
I think it would be crazy these days to rely on any quote from any other source without verifying it as being accurate before you republish the quote.
So the court was saying, in this case, the ordering and arrangement of these quotes allowed the jury to perceive that defamation had occurred. So it wasn't that the quotes themselves were false. It was the way they were arrayed on screen and in the ad. So I guess the idea that an accurate quote makes you immune from liability isn't quite right. But I don't think that overcomes the need for the actual malice when the plaintiff is a public figure.
Yeah. Truth is going to set you free in any situation, I think, whether there's an actual malice standard or not.
Mm-hmm. Well, and it's this tenuous line that, yes, the two statements were true, standing separately, but when combined, they created this false impression that this particular person was the one that he approached for sex, was one of the ones he approached for sex.
Okay, so, do we know that the statements are true standing alone?
It seems like that was acknowledged. Well, let me see. The defense argued that regardless, this. Oh, okay. Well, yeah,
so
I don't know.
There's probably an assertion that were these statements true standing alone, and and then defense asserts they clearly were not true when combined together.
Yes, that it was Wendy Moore who was the one he approached for sex, or among the ones he approached. Very. I don't know. This is troubling. I certainly hope that we see an appeal and there's some clarification about when does this actual malice standard apply, and was the jury correctly instructed in the case? But $8 million is significant.
I think they will appeal simply for the damage award.
Certainly a hometown jury. I guess he's a hometown hero to some folks in Alabama, at least, and they wanted to give him an award for this. I'm troubled in more ways than one.
Right. I think we'll see it again. Yeah, I don't think this one is going to go away. I think there will be an appeal.
Well,
and it was a pretrial decision. Was this a decision that even shouldn't have been resolved pretrial?
You would think. Yeah.
Yeah.
It may be that the defense, ultimately was getting rulings against it in sequence and just, had to go through with it so they could preserve a case for appeal. And I suspect that's where we are. So,
right.
Well, we have a big case that was heard, about a week ago at the 2 weeks ago at the Supreme Court, that we've been following for a long time. And we're looking forward to the the ruling in the case of Andy Warhol Foundation versus Goldsmith. But we thought it would be a good time, since the oral arguments happened last week, we ought to just do a review of the case. So the background is this. It's a copyright dispute over a photograph of the musician Prince, taken by Lynn Goldsmith, a well-known rock photographer. She took the photo in 1981 when Prince was in his up-and-coming phase of things. And that image was licensed by Vanity Fair for use as an artist's reference for an illustration that was going to accompany a profile of Prince that they were running back in 1984. So he had now become a superstar. Purple Rain had come out, and he was becoming a big figure in the industry. And so Vanity Fair hires Andy Warhol to do this illustration and use Goldsmith's picture as a reference. So Warhol cropped and silk screened the photo into a series of 16 images, one of which was published in the Vanity Fair article, the one known as The Purple Prince. And, we all know the Warhol style of the silkscreen image on a canvas with a colorful background, and it becomes much more monochromatic. Well, not monochromatic, but, it's narrowed down to just black and white. No shades of gray. Yeah, exactly.
Yeah.
And so Warhol does this thing, and it appears, and it was published in the Vanity Fair article. And a later one of these images, the one known as Orange Prince, ran on the cover of a commemorative magazine published by Condé Nast after Prince died in 2016. Is it really 2016? Is it really that long ago?
It's really been that long.
Yeah. Well, Goldsmith objected to this later publication using the Orange Prince as a violation of her copyright. And the Andy Warhol Foundation filed a preemptive suit to declare the entire 16-image series was fair use under copyright law because Warhol had transformed Goldsmith's photo into a new series of work with a different meaning and message. So the issues in the case, the crux of the issue is whether or not Warhol's adaptation of the photo is truly transformative and therefore to be considered fair use. The Warhol Foundation's attorney argues that it's because of, if the Warhol Foundation was to lose, countless works of modern and contemporary art would be deemed to be infringement. Goldsmith argues, on the contrary, that while Warhol may have been a creative superstar who imbued other people's art with his own distinctive style, even Warhol followed the rules, and when he didn't take a particular picture, he would usually still pay the photographer who did. And the foundation simply failed to do that in this situation. So the oral arguments. Much of the arguments focus on whether or not this was indeed transformative. The justices' questions tried to stick to that line of thinking, didn't want to wander off into a critique of art. Chief Justice Roberts asked about taking the Goldsmith photo and putting a smile on Prince's face. He said, the message is Prince can be happy. Prince should be happy. Is that enough of a transformation? The message is different. And the Warhol Foundation says, well, that would depend on the degree of the transformation in meaning or message. A number of the questions concerned book-to-movie adaptations, which generally involve licensing. Some of the justice wondered whether or not the foundation's position would essentially eviscerate this key analytical factor of fair use under the Copyright Act. If a work is derivative, like Lord of the Rings, book-to-movie, is your answer then just, well, yeah, it's a new meaning or message, it's transformative, so all that matters is the Copyright Act's, effects on the market factor. This was from Justice Amy Coney Barrett. Justice Kagan asks, there may be nothing left to the original author for derivative works. Indeed, we expect Hollywood, when it takes a book and makes a movie, to pay the author of the book. But I think movie makers might be surprised at the notion that what they do isn't transformative. I mean, mostly movies are tons of new dialogue, plot points, settings, characters, themes. You would think that it amounts to new meaning and message under the test that the Warhol Foundation is proposing. So why is it that we can't imagine that Hollywood could just take a book and a movie and make a movie out of it without paying?
And so I'm just going to interject. I mean, that by definition is transformative.
Mm-hmm.
I mean,
it's the nature of making a derivative work. You're transforming from one medium to another, and presumably adding or taking away from the original message in order to make that happen.
But maybe that's the nature and the purpose factor, the commercial purpose, but yet
Yeah.
Andy Warhol's work are clearly a commercial purpose.
It seems like the
As we
Warhol,
kind of go through the fair use factors, I
yeah,
mean, this is
yeah. It seems like the Warhol Foundation's approach is to elevate transformativeness above all of the other factors that might be considered in a fair use discussion, and say, look, if it's transformative, none of the rest matters.
which I'm going with the two justices and their line of
Mm-hmm.
thinking. There's hardly any art form more transformative than
Mm-hmm. Mm-hmm.
a literary work to an audiovisual work.
Yeah.
But are we going to a place where we're not going to get a license for that and secure those rights?
Yeah.
I don't think so.
Well, Justice Alito took it in another direction a little bit. He asked the question, "What do you think the Second Circuit meant when it yacked about art critics, about judges not being art critics? What was the point? Was the point that a person who knows nothing about either of the works of art is supposed to determine whether they seem different?" And yeah,
Ah,
so
that's true.
yeah,
And then even you could ask 5 art critics and they would give you different
hmm
answers
hmm
because they're a critic. It's subjective.
yeah. So another factor that the justices had to consider is the purpose of both works. It's factor one, the purpose and character of the original, and factor two is the nature of the the nature of the purpose and character of the infringing work, and factor two is the nature of the original. So they look, the images created by Warhol were for commercial licensing for publication in magazine stories about Prince. Goldsmith Original was intended to provide an accurate representation of how Prince looked. Chief Justice Roberts, particularly probed that point and looked at non-representative attributes of Warhol's depiction, emphasizing if you really want to know what Prince looks like, he doesn't have that one eye that's darker than the other, and the head doesn't float in the air as it does in the Warhol, but not the Goldsmith. And according to Chief Justice Roberts, Warhol sends a message about the depersonalization of modern culture and celebrity status, suggesting it's not just a different style, it's a different purpose. One is the commentary on modern society, the other to show what Prince looks like. So that's sort of also, I guess, a discussion of the transformation of the purpose, in a sense. So
Yeah.
pretty hard to tell which way this is going based on the questions being asked. Although I think that many of the justices seemed skeptical that merely changing the medium and changing, certain elements is enough to be deemed transformative. That last bit about, the different message being conveyed, there's something to that, I think. But
But
I don't
I
know.
think we've had this conversation before that the different message conveyed is often a matter of what's been postured in the pleadings.
Yes.
That maybe the artist was not conveying a different message.
Well, isn't it the nature of art, though, that if the artist has to explain its meaning, then, it's going to be different from one, what's the word I'm looking for? From one viewer. Beauty is in the eye of the beholder, essentially. So,
Right. It's subjective
so isn't
as
Warhol's
to
argument
what
essentially then, well, if it's capable of being perceived as having different meaning, then that's enough of a transformation. But couldn't you say that about the original as well?
yes. And so
So,
now let's say I want to put the Warhol orange image on greeting cards and sell them.
mm-hmm.
Who am I getting sued by?
Everybody.
Okay, just checking. But because everybody's going to claim,
Yeah.
that they have something. So that's interesting.
Yeah.
I did not look at the case to know did Warhol or the Warhol Foundation file a copyright application
Oh, interesting.
for his new works?
Yeah.
And if so, did they claim that there was any pre-existing material? They should,
They're
because there
supposed
was
to.
clearly
Yeah.
pre-existing material.
Yeah, but so is declaring something to be a derivative work essentially acknowledging that it's not fair use?
I don't think so.
I don't
I
think so
think you
either.
can have a derivative work that's still fair use.
Yeah.
Because
But
by nature, it is a derivative work. It continues the line of thinking of the
yeah.
book to the movie. There's no doubt the movie, well, I guess there could be doubt. We talked about this with the Top Gun
Yeah.
case last month,
Yeah.
month
Yeah.
before last, that the person who wrote the first article is the second, is the Top Gun Maverick movie, a
Yeah.
derivative work of his article.
Hmm.
That's another case that's going to be, I think, did we determine if they'd filed? I don't remember if they'd filed a lawsuit or not, if there was just conversation about it. So
Yeah.
I don't know.
I don't remember. But, well, I mean, it does strike me that checking the box on the copyright registration form could be used at least as an admission at a certain level that there's, well, alleged infringement.
You
at
you
least.
acknowledge there's a portion of your work that is, I think you acknowledge that there's a portion of your work that's not protectable by your copyright registration.
So if I do my adaptation of Romeo and Juliet, do I have to check the box and acknowledge that it's based on Shakespeare?
I think you do,
I think you're probably right.
because there's
Yeah,
a
that it's
portion.
based on
Yeah,
some
I
public
think
domain material. Yeah.
some public domain material.
Okay.
There's a portion of it based on public domain.
Yeah.
Now, is it? I'm trying to think of any of the more recent
Yeah.
kind of Romeo and Juliet-esque movies that were, teeny bopper,
Well,
teen angst
and
movies. But
where, yeah, and where does
and
just the theme of boy meets girl under dire circumstances sort of become?
West Side Story.
Well, yeah. I mean, that one's an obvious remake of the Romeo and Juliet story, but there are, boy meets girl is a theme. It's not even
Yes.
underlying. Yeah. So, well, anyway. Well, let's move on to this next story, which is sort of just something we've. I was going to say put it in for fun, but it's sort of a couple of alarming components to it. So, there are two cases dealing with these police departments in Ohio. The first one, The Onion, the famous parody website, has filed a petition for cert. Filed an amicus brief in a petition for cert to the Supreme Court over a police department and its Facebook comments battle. So the case is Davis versus Coleraine Township. Am I getting it right? Is this the right one? The Sixth Circuit held that Davis lacks standing for one of her challenges, that the other challenges moot. I think we've got these facts back. So let's do Davis. Carrie Davis is very vocal about this township's board of trustees and police department, and she usually provides her critiques in two different ways: one by oral comments at board meetings, and the second by written comments on the police department's Facebook page. One incident occurred at a board meeting in which Davis was told that she could not speak disrespectfully, and another when she stated, "Our firefighters and police officers, they don't have bachelor's degrees, but their certifications speak for themselves too. So you don't have to have a bachelor's degree in order to be wholly competent and qualified for your job." So some weeks later, the chief of police made a post stating, "Recently, a citizen commented that most of our officers don't have college degrees." Davis claimed that this post misrepresented her statement and that others began ridiculing her, this citizen. So Davis uploaded her video showing the context and included a comment about the matter. She alleged that the video received likes from the public, but the next day the video and the comment were taken off the page. She contends that there are three rules that are facial constitutional challenges. One rule is that the township's rules regulating public statements at board meetings, passed in 2010, stating that condescending comments would not be tolerated and that speakers should show respect to the board. The second rule is the police department's rule regarding comments on its Facebook page, which states the department reserved the right to remove any comments or reviews that are inappropriate or offensive, including comments that express racism, hatred, slander, threats, obscenity, violence, or vulgarity. And the third rule by the police department is that the posting of photos or videos by anyone other than members of the police department is banned or barred. So the police department's two different rules on the Facebook situation. So the district court granted summary judgment in favor of the township. The court also held that the rules comported with the Constitution since the comments section of the Facebook page and the public participation portion of board meetings were limited public forums. The court rejected Davis's contention that the rules were overbroad and vague, and found that the rule barring disrespectful speech wasn't applied to Davis in a discriminatory way. So the court said Davis didn't satisfy the case or controversy requirement for the Facebook rule challenge, and that the meeting rule was recently appealed, which makes her case moot. So the standing analysis, Davis is looking for retrospective relief for past injury, damages for the purported removal of her video from the Facebook page, and prospective relief for future injury, an injunction and declaratory judgment against any application of the Facebook rule to her future speech. On the past injury, she can't satisfy causation because the injury isn't fairly traceable to the Facebook rule. It was caused by the no videos rule, but instead she's challenging the rule that bans inappropriate or offensive comments. And on the future injury side, she hasn't shown that the department will, in fact, apply the rule to her in the future. And she needs to show that there's certainly impending injury. So fails on that. On the overbreadth analysis, the court found that there's no relevance. It's not an exception to the Article 3 injury. In other words, you didn't get far enough to get into that. On mootness of the meeting rule, the board apparently in July of 2021 repealed the meeting rule that barred the disrespectful speech, unanimously voting on the amendment in a formal legislative-like meeting, whatever that means. And the minutes show that this decision was due to an external factor separate from Davis's suit. Another case, this is the one that I referenced, The Onion. I don't know why we got this sort of out of whack here. Novak versus the city of Parma, Ohio. Novak had created a fake Facebook page that looked like the Parma Police Department's page. And he believes that his post should have been protected as parody. It was similar in look, but it had jokes and weird headlines and snide remarks and things like that. So he was arrested and charged with a state crime of interfering with the police department's activities. He was acquitted on those charges, and then he filed a civil rights suit claiming that his constitutional rights were violated. The Sixth Circuit rejected those arguments and found for the police department. So The Onion has written an amicus brief to the Supreme Court supporting a granting of certiorari, and they talk about the nature of parody. And in fact, inside the brief, there are parodies included, and they sort of talk about it wouldn't be a parody if we had to tell you up front that it's a parody. Announcing it's a parody sort of deflates the value. And anyway, so the main reason I wanted to mention that is that it's a fun read, the brief itself. So we'll link to that.
Yeah. But what concerns me though is I can appreciate parody and how parody should be protected, but not when it comes to the police department and someone who is seeking, what if, worst case scenario, someone is in a terrible, terrible, terrible situation.
Yep.
And the only access they have to try and get their cry for help out is through Facebook, and they go to his parody Facebook page. I don't think you get to pretend to be the police, no matter how funny you are.
So the stripper shouldn't wear a police uniform to go to the party to do the, the
I
slippery
think
slope.
but I think that's different. I think that because it's a one-on-one in-person interaction that you can easily determine that it is not truly a police officer. I think it is different on social media and the Facebook that if you're okay, so let's say somebody decides to be me on Facebook and make jokes. I can't take that down? I don't know. But I think it's different with the police. I think there's a different standard
speech,
there.
and the difference between you and a police department is you're not the government.
Yeah.
Speech is speech. And I mean, we have to assume for a minute that the speech on, it wasn't hate speech, it wasn't inciting violence kind of speech. It was making jokes about this police department, which apparently isn't capable of taking a joke. But it seems to me that this is exactly what the First Amendment is about. Is we should be able to make fun of the police department. We should be able to tell jokes and so, and yeah, what they were saying, what the police department seems to be saying is, hey, you should have put up a banner or something that said this is a parody website. And the Onion's argument is, but then it's not the same speech. We're making it's a different impact.
Yeah.
And
I think this is an interesting one.
Yeah.
For a lot of different reasons, and we've had a couple of episodes where we've talked about social media and governmental entities.
Yeah.
And so, I feel like we've got kind of a trajectory where we're going to be getting some decisions related to these various cases, and hopefully they'll give us a clear path forward as to what's allowed, what's not allowed, what's defensible, what's not. So I haven't looked at the parody Facebook page. Maybe it is so abundantly clear that it's not the police.
Well, I mean, look, I think I did look at it, and look, it's similar in design to the real police department page. It's similar, but it's got just ridiculous things on it that no real police department would ever have on their website. And so, to your concern about the citizen in need landing on this page and either finding misinformation or not being able to avail itself of police services, I think, we have to assume that people are going to be able to figure it out. But do you have to put a big bright banner on the top of the screen in order to warn people? And I don't know if a citizen was claiming an actual injury, I think there might still be a civil case for damages as a result.
Maybe.
But for the government to say to arrest him and charge him with a crime.
That may be taking it a long ways to actually arrest someone.
Well, and there's a long history of comedians being arrested on obscenity charges, things like that. You go back to Lenny Bruce and George Carlin and those folks. The First Amendment, comedy and parody have been, I think, a major forces in the development of First Amendment jurisprudence, and so this will be interesting to watch. Yeah, I hope it gets be an interesting oral argument to attend.
Oh my gosh, yeah, it'll be a good read. Well, and obviously it's already a good read for the brief that's already been filed. So we do have just a reminder practice pointer. So first, if you practice trademark law at the USPTO, things are moving at a dirge. So I don't have the current stats in front of me about how long it's taking for initial application reviews to be. Yeah. It's a good 9 months before they're being reviewed, and I don't think that's getting any better. So I'm just throwing that out there. So office actions, which are after your application is reviewed, the examiner, 50% of applications receive an initial refusal in the form of an office action. Up until December 3rd of this year, if you get an office action on any of these long pending applications, you'll still have 6 months to respond. December 3rd, it changes to having 3 months to respond to your office action. If you want an additional 3 months, there's a fee involved, and I think you have to check a couple of boxes as to why you need that extra 3 months, but you're going to pay $125 to receive that. So this is really important. My whole time of being a lawyer, it's been a 6-month response period.
Yeah. And
sometimes there's reasons why you want to use the whole 6 months to respond. But now we've got to really reset. We've actually, myself and my assistant have already redesigned our task list workflow to deal with a 3-month response so that we are on top of it immediately and making sure we're on top of our client. If
I think that's where the real bottleneck often is the client.
And that's it. And if there's no waiting to day 80, I don't think, before you talk to your client, or you're going to be in big trouble to try and meet this 3-month deadline. So,
yeah. So just a practice pointer out there.
I also wonder.
Go ahead. Sorry.
Oh, I was just going to say, I wonder if examiners are going to be waiting to release refusals. I wonder if they're holding. I don't know.
Boy, you're suspicious. Yeah, it's a good question.
Or maybe they're rushing them through because they want 6 months for you to respond. I don't know which way it'll be.
I think they probably have their own, reporting responsibilities. They'll get scrutinized if they're not releasing them as fast as they, within a certain amount of time as after they're assigned the case. And the backlog seems to be in just being assigned to an examiner. My experience is once the examiner has it, I get a response of some sort relatively quickly.
I think that's right. I'm looking at some things that were filed in February of 2022 that still have not been assigned to an examiner.
Yeah.
Both my own applications I've filed and then some other third party ones that I'm just keeping an eye on. That we're going all the way back to February.
I think I have at least one that was filed in the middle of 2021 that still I don't have any assignment.
Wow.
I've been chasing after it and trying to get answers.
Yeah. So even in post-registration filings, what I have found on those, you can seem to call and get a person on the phone and they will get it reviewed. But for new assignments, there doesn't seem to be anything to speed it up. So that said, the trademark office is going to be speeding us up. So
wait. Now hurry up and answer.
Yes, that's exactly right. Now get it together.
Yeah.
So, change your workflows, lawyers, so that you now are set up for a 3-month response period instead of a 6 months response period to those office actions that are coming out.
Yeah. Well, listen, that is it for this episode of Entertainment Law Update. Thank you so much. And heed that practice pointer for sure. But we want to take a moment to thank you, our loyal listeners, for spending your time with us. And of course, we welcome your feedback. If you'd like to send us email, you can send it to entertainmentlawupdate@gmail.com or visit our website at entertainmentlawupdate.com, where we have a widget. You can click on that and record your voice, and we love to play those things on the air when we get them. On Twitter, we are at EntLawUpdate. And Tamara, tell folks how to reach you.
Yeah, I enjoyed it as always. Super fun. We'll see if you guys actually see our faces, but you'll definitely hear our voices for our 150th episode. Online, social media at Tamara Bennett, TaMeraBennett, tbennettlaw.com or createprotect.com will take you to my website. Gordon, had a blast. Thank you so much.
Fun. 150 episodes and more to come. So I'm Gordon Firemark from Los Angeles, and my website is at firemark.com. The email address, gfiremark@firemark.com, will get to me. And on most social media websites, gfiremark is my handle. Let's say a big thank you to our crack team of volunteer contributors, managing editor John Janasek, Malhar Oza, Charles Thorne, Mark Lindeman, Carneal Wilson, and David Tobis all helped and contributed to this episode. And we are actually looking for some new people to join our family of contributors. So please reach out to us. entertainmentlawupdate@gmail.com is the place to go. And with that, we'll wrap up this episode of Entertainment Law Update. Thanks again for listening. And until next time, that's showbiz.